Imagine you are buying what you believe is a genuine antique Ethiopian cross from the 18th century. You pay 50,000 birr. Later, you discover it is a modern replica worth only 500 birr. Would you have signed that contract had you known the truth? Of course not. This is exactly where Article 1697 of the Ethiopian Civil Code comes into play. Let us look at the exact words of the law. Article 1697 of the Ethiopian Civil Code states, under the heading, "Mistake must be decisive," the party who invokes his mistake shall establish that he would not have entered into the contract had he known the truth. This short provision carries enormous weight in Ethiopian contract law. It sets the threshold a mistaken party must cross before a court will invalidate a contract on the ground of mistake. Now let us break this provision down element by element so you understand exactly what it requires. The first element is the existence of a mistake. A mistake, in the legal sense, means a false belief about a fact or circumstance at the time the contract was formed. The party must show that when they gave their consent, they were operating under an incorrect understanding of reality. Without a real mistake, there is nothing to invoke. The second element is the burden of proof. Notice the words "shall establish." This places the burden squarely on the party who claims the mistake. The law does not assume mistakes. If you want to escape a contract by saying you were mistaken, you must prove it. The other party does not have to prove you were correctly informed. This is a crucial point that students often forget. The third element and the heart of Article 1697 is decisiveness. The mistake must be decisive. What does decisive mean? It means the mistake was so important, so fundamental, that without it, the party would never have entered the contract at all. A small or trivial mistake is not enough. If you would have signed the contract anyway, even with full knowledge of the truth, then your mistake is not decisive and the contract stands. The fourth element involves how courts measure decisiveness. Article 1697 uses a subjective test, focusing on the particular mistaken party. But Ethiopian legal scholars and courts also apply an objective check. The court asks, would a reasonable person, placed in the same circumstances and with the same characteristics as the mistaken party, have refused to enter the contract had they known the truth? This combined approach prevents people from using minor or invented mistakes as an excuse to escape contracts they later regret. Remember, contracts must remain stable. The law cannot allow easy escape routes. A fifth element to remember, although it comes from Article 1703, is consequences. Even if a mistaken party successfully invalidates a contract under Article 1697, they may still be liable to pay damages to the other party for any loss caused. The mistaken party escapes this liability only if they prove the other party knew or should have known about the mistake. So invalidation is not a free ticket. Let us now apply Article 1697 to a concrete scenario. Almaz, a coffee exporter in Addis Ababa, signs a contract to buy 1,000 quintals of coffee beans from Bekele, a farmer in Jimma. Almaz believes the beans are premium grade 1 Yirgacheffe coffee, which she plans to export to Europe at high prices. After delivery, she discovers the beans are actually grade 3 commercial coffee, worth far less and unsuitable for her European buyers. Almaz wants to invalidate the contract under mistake. To succeed under Article 1697, Almaz must establish two things. First, that she genuinely believed the beans were grade 1 Yirgacheffe at the time of signing. Second, and most importantly, that she would not have entered the contract had she known they were actually grade 3 commercial coffee. Given that her entire business purpose was exporting premium coffee to Europe, and that the price difference is enormous, a court would likely find this mistake decisive. A reasonable exporter in her position would not have signed such a contract knowing the truth. However, Almaz may still owe Bekele damages under Article 1703 unless she can show Bekele knew or should have known about her mistaken belief regarding the grade of coffee. Now contrast this with a different situation. Suppose Almaz mistakenly believed the beans would be delivered in jute sacks, but they arrived in plastic bags. This mistake is trivial. She would clearly have signed the contract anyway. The mistake is not decisive, and Article 1697 cannot save her. For your exam, remember these key points. First, Article 1697 is about decisiveness, not just any mistake. The mistake must be so fundamental that the party would have refused to contract had they known the truth. Second, the burden of proof is always on the party invoking the mistake. Third, courts use both subjective and objective criteria, asking what a reasonable person in the same position would have done. Fourth, always connect Articles 1697 with Articles 1698, 1699, and 1700, which describe the types of mistakes the law recognizes, such as mistakes on the object or on the person. Article 1697 sets the gate. The other articles describe the keys. Fifth, never forget Article 1703 on damages. Examiners love to test whether students remember that invalidation has financial consequences. A common exam trap is mixing up mistake with fraud under Article 1704. Mistake is unilateral and unintentional. Fraud requires deception by the other party. Another trap is confusing mistake with arithmetic errors under Article 1701, which are mere computational mistakes corrected without invalidating the contract. Read the question carefully and identify which type of defect in consent is involved. Thank you so much for watching. Whether you are a law student preparing for your exams, a legal practitioner brushing up on contract principles, or simply a curious citizen wanting to understand Ethiopian law better, we appreciate your time. Please subscribe and join us for more clear, exam-focused lessons on Ethiopian law.